Sri P. Wilson. Sri P. Wilson.
I rise today to speak, not maiden. I rise today to speak against the Unlawful Activities Prevention Amendment Bill 2019. And DMK party is opposed to the said bill in the present form and manner it has been introduced. Therefore, our first suggestion is to refer the bill to a standing or a select committee for an in-depth study and consultations. The intention of the Honorable Home Minister to curb terrorism is a welcome measure, and we don't stand against any law which really deals with the terrorism. Terrorism is a great threat to the humanity and society and requires to be curbed with iron hands. We would join hands with you if such real measures are taken, and please look upon us as a constructive opposition. Our concern is that the present amendment bill is in effect an assault on the rights guaranteed under Part 3 of the Constitution, and in particular violative of Article 14 and 21 of the Constitution. It is subject to misuse and abuse by the central government. Honorable Sir, a spade can be called as a spade, but can you call a person as a terrorist merely on one's own belief, even without a judicial declaration? The amendment bill is highly discriminatory when it is concerning individuals and associations. Probably the draftman of the bill is not aware of the dimensions of Article 21 and its vigor and tenor and its applicability. He puts the rights of an individual and an organization in the same scale. Honorable Minister Sir, the discrimination which I wanted to clarify is, when it comes to a declaration of an association as unlawful under Section 3, the central government has a power to declare any association to be unlawful by way of a notification, and the notification should specify the grounds on which it is issued and such other particulars. However, this declaration shall not take effect till the tribunal gives its approval under Section 4. Under Section 4, there is a provision where the central government, after declaring an association as unlawful, shall refer it to the tribunal for its adjudication. The tribunal, which consists of a judge of the High Court, a retired judge of the High Court, he shall inquire into and give notices to the parties and then decide the issue. However, if you see, so far as the persons who is being branded as a terrorist, no such safeguards is seen. The procedures under Section 7 and 8, which allows to make an application before the district court as against the order of the central government, is also not available when it comes to branding individual as a terrorist. The treatment of a terrorist organization under Chapter 6 is slightly different. However, organization, except for being a juristic person, cannot be equated with that of an individual who has a galaxy of fundamental rights and other rights under the Constitution. The exercise undertaken by the draftman of the bill is to fit an individual and treat him on par with that of an organization. That cannot be countenanced in law. An individual is now sought to be fit into Chapter 6 by altering Section 35, 36 and inserting 4th schedule. Without laying sufficient foundation, such alterations of Section 35 and 36 will no result. The amendment will collapse. This amendment can call any person as a terrorist by a simple belief of an officer of central government that he is involved in terrorism. For arriving such belief, a person is a terrorist. The bill has not provided time-tested procedures, safeguards, and the individual rights and liberties are at stake. The Act doesn't name who is the officer of the central government in the Ministry of Home Affairs who is going to call a person as a terrorist. No similar procedure as laid down under Section 3 and 4 before declaring unlawful organization is available before an individual is branded as a terrorist. The problem of branding a person as a terrorist by whims and fancies may arise. The officer of the central government is not a judicial authority. The Act does not provide as to how such belief could be arrived. The authority need not conduct an inquiry. The Act is silent whether there should be any materials available for the central government before declaring a person as a terrorist. Thus, unguided, unbridled, uncanalized power is conferred on the central government to declare any person as a terrorist, and no procedure to be followed is laid under the Act. The principles of natural justice is not given. So far as the procedure that is available under Section 36, that is available for a terrorist organization, after he has been declared as a terrorist, he has to make an application before the review committee, which means that the application first has to be made before the central government, and when the central government rejects the application, then the matter has to be taken before the review committee, which means whatever that procedures that is available for an organization under section 3 and 4 is not available for an individual. What is available is only a
conclude. Your
review
time is
committee.
over.
I therefore request the Honorable Minister to frame sufficient, to include sufficient safeguards as such found under section 3 and 4 for an association, and similar safeguards may be made available so far as the individual is concerned.
Thank
That
you,
is the
Mr.
reason we are asking the Honorable
Thank-
Minister to refer the bill to a standing committee.
Thank you,
The bill
Mr.
as such
Wilson.
in this form is opposed by us.
Thank you, Sri